Hello everyone, I'm Anuj Nakade and you're watching Live Law. Today on the 21st of August, the Gujarat High Court faced strong criticism from the Supreme Court in the manner it passed an order in a rape survivor's plea seeking abortion. You may remember that last Saturday on the 19th of August, the Supreme Court held a special sitting to hear a rape victim's plea to terminate her pregnancy nearing 28 weeks. The Supreme Court observed that despite the urgency in the matter, the Gujarat High Court had adjourned the matter to be heard 12 days later and then advanced the hearing only to dismiss the petition. However, the order of dismissal was not uploaded on the date even though the Supreme Court had taken up the matter 2 days later in appeal. A division bench of Justice B.V. Nagarathna and Justice Ujjal Bhuyan had criticized the High Court for handling the matter in a lackadaisical manner on Saturday. In this backdrop, the Supreme Court had sought for an explanation from the High Court registry after observing that valuable time was lost due to High Court's approach and posted the matter to be heard today, on the 21st of August 2023. We covered the courtroom proceedings that happened on Saturday in this case in a previous video, which you can watch from the link in our description. When the matter was taken up today by the same division bench, the court was informed about another order passed by a single judge bench of the Gujarat High Court in this matter on Saturday, after the Supreme Court had heard the matter that morning. In this order passed by the High Court, the court attempted to clarify that the order of adjournment was granted in order to enable the counsel for the petitioner to get instructions from the woman if she was willing to give the child to the state's facility. The Supreme Court bench took great exception to this clarificatory order passed by the High Court. Justice B.V. Nagarathna, while expressing her extreme dismay, said, and I quote, "We do not appreciate the High Court's counterblast to Supreme Court's orders. What is happening in the High Court of Gujarat? Do judges reply like this to the Superior Court's order? We do not appreciate this." Justice Bhuyan weighed in to observe that the High Court could not have imposed an unjust condition on a rape survivor, forcing her to bear the child. He said, and I quote, "The view taken, I'm sorry to say, is against constitutional philosophy. How can you perpetuate unjust condition and force the rape survivor to undergo pregnancy?" At this juncture, Solicitor General of India, Tushar Mehta, appearing for the state of Gujarat, requested the bench to refrain from making comments about the High Court judge, while adding that the petitioner can be granted relief. He said, and I quote, "Some misunderstanding was there. I think your ladyship might leave it at that. Please ignore." Justice B.V. Nagarathna, while still baffled by the need to pass such an order, retorted to this request of the Solicitor General, saying, and I quote, "How can we ignore? No judge can counterblast the Supreme Court's order." The Solicitor General again requested the bench to not make any adverse comments against the single judge bench of the High Court, saying, and I quote, "He is a good judge. Comments can be discouraging." Upon hearing this, Justice B.V. Nagarathna clarified that the comments are not against any particular judge, but the manner in which the matter was dealt with. Senior Advocate Sanjay Parekh, who appeared for the petitioner, told the bench that the same judge in another case related to pregnancy of a minor rape survivor had invoked the Manusmriti. Senior Advocate Parekh also made a request to the bench for allowing the preservation of tissues of the fetus for use as DNA evidence in the rape case trial. After this, the bench took note of the medical report which was in favor of the woman's plea. In the order, the court has observed that while pregnancy in a marriage is an occasion for joy, pregnancy outside marriage, especially as a result of sexual assault, is injurious to the mental health of a woman. In light of these observations, the court said, and I quote, "We permit the appellant to terminate her pregnancy. We direct her to be present in the hospital today or 9 a.m. tomorrow so that the procedure for termination of pregnancy can be carried out." However, the court also directed that in the event that the fetus is found to be alive after the medical procedure is to be carried out, the hospital is to give all facilities including incubation to ensure the survival of the fetus. The state then will be directed to take steps to ensure the child is adopted in accordance with the law. The court also refrained from making any comments on the order passed by the Gujarat High Court on Saturday, the 19th of August. Regarding the plea made by Senior Advocate Parekh for preserving the tissues of the fetus for use as DNA evidence, the bench said that it can only direct the doctors to explore the feasibility of this plea. That's all we have for you in this video. Hope you found this video informative. If you did, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. For more details, please visit our website at www.livelaw.in. If you'd like to support the work we do here, please consider joining our channel as a member for only ₹89 per month. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.